Good evening, everyone. I hope everyone is doing well wherever you are right now. So, welcome to our 10th episode of the Strata Talk Show. I'm Amiza and I'll be your host for today's Strata Talk Show. And this talk show is brought to you by Excel Academy of Real Estate. All right, and Mr. Patrick will be our guest speaker for tonight's talk show. And for today's episode, we'll be talking about the defective premises, who is responsible. So, guys, if you have any questions, feel free to post your question in the Facebook comment box below. And please do not forget to click on the share button and help us to share this live event as well. Okay, and hopefully by end of this session we can answer all of your questions. All right. So Mr. Patrick, are you doing good today?
Yes, I'm okay, fine, thank you. All right.
All right, good to know that. Great. All right, so without wasting time, let's welcome Mr. Patrick to start the session now. I'll pass to you, Mr. Patrick.
All right, thank you. Thank you very much. All right, good evening to each and every one of you. All right, it's good to see all of you here in this new year. So it is a blessed New Year 2022 and also a blessed Chinese New Year in this year. So with all the celebrations and all the fireworks, hopefully 2022 will light up and look good in this coming year in the real property market as well as in related matters. Today's topic is still on the defective parcels or defective premises, and the question is, who is responsible? It is very common. I was just thinking the other day, I remembered an incident not related to real estate, but an incident in Penang. I taken my wife's Proton Vira for servicing at the Aeon Service Center. We had purchased his car new. And while I was there was a lady who was arguing with the service manager and service advisor. And her argument was she had bought this brand new Vera as well. And the stickers at the car door were all peeling out. And the covers for the car seats were all coming out. And she was like, I can't understand. This is a brand new car. Why are these things happening? And then the service advisor was telling her, look, madam, the company which sold you the car is different from the company which services your car. And the company which services your car is different from the company which supplies the spare parts to you. So what we have is, we have a company which sells the car. We put it all under Aeon, we put it all under HiCom, whatever name it is. But there's one company selling the car, another company servicing the car, and yet another company which supplies the parts. So if you are unhappy with any part of your car, who do you sue? Where do you lodge your complaint? I mean, this lady was telling that this, look, you are servicing the car, you should take care of it. They're saying, look, it's not our responsibility. We only service you for every 5 or 10,000 kilometers, and that's our job. Anything else to do with the car is not our responsibility. The same problem can occur in a stratified development. When you have a problem, whether it's a leak, whether it's a crack, whether it's wiring or plumbing or your sewage problem, where do you take your complaint to? Who is responsible for this? Now, in answering that question, we need to start by looking at your relationship. Let's assume that you are purchasing your property from the developer. Then your relationship with the developer, first and foremost. Your relationship with the developer is basically threefold. First of all, there is a statutory relationship if you are purchasing a residential parcel, because you will be protected by the housing rules. the various schedules that are given there. And you will be able to rely on statutory provisions, for example, relating to LAD, to bring your claim against the developer. The courts have said the LAD sets the standards. You cannot claim above that LAD amount, the formula given there. You cannot claim below. So that's the standard that is given to you. Number 2, you have a sale and purchase agreement and the deed of mutual covenants, and therefore you also have a remedy under the law of contract. Thirdly, you may have a remedy under the law of torts. So there are 3 avenues available to you when you purchase a property from the developer. It is a brand new property. It is governed by statute, is governed by a sale and purchase agreement and your deed of mutual covenants, as well as by the law of torts, in particular, the law of negligence. For those who are purchasing was second-hand purchases, if they are buying directly from a purchaser who bought from the developer, then your remedies is still available against the developer. But if you're buying some years later, then you may not have a remedy against the developer, but your remedy may lie elsewhere. Today, very briefly, we're going to have a very a good overview of this situation. Now, let us start. The relevant questions that we need to ask. First of all, first question, in a stratified property, are you talking about damage and or defect to your parcel or accessory parcel? Or are you talking about damage and or defect to common areas? Number 1. Number 2, is your complaint or the nature of your grievance, is it regarding non-compliance with specifications? For example, maybe the type of door that is given to you is cheaper than what you expected or what was stated in your sale and purchase agreement. Is your complaint about defective workmanship? Paintwork is not good. The finishing is not good. Floor tiles are not even. Is it regarding defective workmanship? Or 3, is it regarding the poor quality of the materials? So 3 aspects. It could be non-compliance with specifications. It could be defective workmanship. It could be poor quality of the materials used. Take a simple example. Maybe the external part of your wall, there is not enough, or the part of the wall that is exposed to the weather, there has been no waterproofing to prevent moisture from seeping in. It could be that. Now, the third question to ask. So let me repeat. The first question is it damage to your parcel, accessory parcel, or is it damage to the common areas? Number 2 is the nature of your complaint failure to comply with specifications or defective workmanship or quality of materials? Question number 3, is the defect patent or latent? By patent, we mean it's quite clear. You can see the defect, cracks on the wall. Maybe a plaster ceiling is in bad shape. The floor tiles are not even. These are very patent defects. Or are they latent defects? Defects which only appear much, much later in the day. It's number 3. Number 4, what are the express terms of the SPA and your DMC? And number 5, what are the implied terms of your SPA and DMC? The courts in England have implied certain terms into the contract. In particular, there are 3 types of implied terms. That a builder is to do his work in a good workman-like manner. This is what we mean by satisfactory quality. He must do his work in a good workman-like manner. Number two, you must supply good and proper materials which are suitable for the type of building, depending on your height, location. Number three, it must be reasonably fit for human habitation. And that is why you cannot give vacant possession without electricity supply, without water connections, etc. Right? So the three implied terms are builder to do his work in a good work-like manner, must supply good and proper materials, and it must be reasonably fit for human habitation. These are the 5 questions that you need to keep in mind when you talk about defective parcels or damage to your parcels. Who do you sue? Number one, of course, is the developer. You can sue the developer in a number of situations. Number one, LAD, failure to deliver vacant possession of your parcel within the stipulated period. That is, we're talking about within 36 months. Now, sometimes the developer is ready to give you the key. And when he gives you the key, you may go and inspect the premises together with a representative from the developer. And you might notice there may be patent defects. If there are patent defects, you can refuse to take vacant possession of the premises. And therefore, you can later sue the developer for LAD. Because the developer cannot just throw the key at you and say, any damage, any defect, you let us know, we will repair. If the nature of the damage is such that no human being reasonably can be expected to live in that premises in that kind of situation, then you don't take the key. Don't take vacant possession. What if your block is in the 7th floor, 10th floor, and the lifts are not working? Don't expect people to walk up 7th floor, 10th floor every day. Although the lift is a common facility, still it should be ready at the same time as vacant possession is given to you. That is why the first question is, we talk about defects to your parcel or defects to the common property. Now, the second thing for the developer is failure to deliver the common property and common facilities within the stipulated period. Of course, we have case law in 2021. The federal court in Malaysia has decided that calculation of LAD commences not from the date you sign your SPA, but from the date the deposit is paid. Please note, the payment of deposit before signing SPA is actually illegal, but the federal court has held that the housing development rules are a social legislation meant to protect innocent purchasers. The developer cannot rely on his own illegality, on his own wrongdoing, and hide behind the law. So there's a 2021 decision clearly stipulating that time starts running from the date the deposit is paid. The booking fee is paid. All right. Now, one of the things that I would like to touch on here is this. One question which is not answered properly, and I think it is food for thought. Assuming that you have defective premises and you are still within the LAD period, and you have lodged a complaint in writing to the developer asking the developer to rectify the defects, and you have given the 30 days notice. The law requires that within 30 days, the developer is to respond to you and is supposed to take the necessary action. But he does not do so. So you wait. So you then, according to the agreement, scheduled agreement, you inform the developer that if you do not repair the premises, you will repair the premises and you will bill it to him. And the developer keeps quiet. Next question. do you go ahead and repair the defects? Do you rectify the defects? Or is it enough if you get a quotation from a contractor saying, these are the expenses? And then you go back to the developer and say, look, I'm going to sue you for this amount. Must you repair the place first? Or is it enough to get a quotation? In 2016, in a case called 𝐒𝐭𝐫𝐚𝐿 Perumal and Banda Iko Satya, the judge said it is sufficient if you get a quotation. However, in another case in 2019, reading the exact words of the statutory provision, the High Court judge said you must actually carry out the repairs. It is not sufficient to give a quotation. The reasoning for the later decision is because of the use of the word recover, to recover from the developer. You can only recover something if you have expended money. Merely getting a quotation is not sufficient. But please note, both of these are High Court cases. They are not binding on one another. The trend of precedent seems to show that getting a quotation is sufficient, but the 2019 decision seems to suggest otherwise. So this is something for you to think about, whether it's enough to get a quotation or whether you need to actually carry out the repairs and then claim back the money, right? Next one. Now that's the first part of the developer. That is regarding the sale and purchase agreement. That is also regarding the DMC and the scheduled agreements. Very few people are aware that once vacant possession has been delivered, the developer still manages the place for the next 12 months at least, until the first AGM of the JMB. This is providing the strata register is not open. The strata register is not open. The developer, after handing vacant possession, will manage the place for a period of 12 months. And then the JMB's first AGM is called and he hands it over to the JMB. Section 9, subsection 1 of the Strata Management Act provides that it is the duty of the developer to maintain and manage the buildings. So you can sue the developer under section 9 as well for failure to maintain and manage the buildings. Now, if the strata register is already open, then the MC will come into existence. But as we are aware, the MC's first AGM cannot be held until 1/4 of the share units have been issued. In the meantime, the developer will manage the place, and this is called the preliminary management period. So note, where vacant possession is given, strata register is not open. For 12 months, the developer maintains the place until he hands over to JMB. That's called the developer's management period, section 9 sub 1. Where the strata register is already open, MC is already formed, but until the MC gets their 1/4 share units aggregate, the developer will manage the place on behalf of the MC under section 48 subsection 1. This is called the preliminary management period. Now, in this preliminary management period, a very interesting point I want you to take note of is this. If you have a statute books, please do look at it. Okay. Please look at section 49, subsection 2. Without prejudice to any other remedy available against a developer, if any developer fails to comply with subsection 1, the developer shall be liable for any loss or damage suffered by the management corporation or any proprietor. Okay? So, the developer is also liable. That's the second way. So, you have the developer. So, let me put it into context again. Developer is liable because of the SPA and the DMC. The developer can also be liable during the developer's management period. And thirdly, the developer is also liable during the preliminary management period. 3 occasions. Section 9 and Section 48. That's the developer. Number 2, whether you are a purchaser with the developer or you're a subsequent purchaser, you can bring an action against the developer for failure to manage and maintain the place in a proper way. Keep that in mind. Next, you can also sue the JMB where the JMB has failed to maintain and manage the place in a proper manner. Right? This is under Section 15. Section 15, Section 19, Section 21 of your Strata Management Act. And finally, you can sue the MC under Section 59 of the Act and the subsidiary management corporation, if any, under Section 64. One of the things that is overlooked very often is the fact that there's provision for insurance. Of course, there's insurance against fire and things like that. What does the insurance cover? Section 93 talks about that. So you can have a look at Section 93 regarding insurance. But what I want to highlight is the law provides that the owners of parcels in a particular development can pass a special resolution to cover specific risks by insurance. This is provided for in, for example, Section 21, subsection 1, paragraph D for JMBs, and Section 98 overall for the MC. So you have your remedy against the developer, you have your remedy against the JMB, you may have a remedy against the MC. If the damage comes as a result of another parcel owner doing some work on his premises, that might come under what we call various kinds of leakage, inter-party wall, or interfloor leakage. In that case, you will have to sue the owner of that parcel under the law of nuisance, because the law provides in your schedules, in your regulations, that all parcel owners have a right to protection of your wall and the floors. So those are your remedies which are available. But in that case, you will have to inform the management. The management will have to come and do an inspection of your place, inspection of the parcel or the person who is at fault, direct that person to make the necessary repairs. And if they fail to carry out those repairs, then the management is supposed to carry out the repairs and charge it to them. So in that sense, you can bring an action against the management for failure to carry out their statutory duties. So essentially, this is what happens, right? This is what happens. Now, going back to the developer, please take note that there are additional protection for you as a purchaser, original purchaser. 5% of your sale and purchase agreement price will be maintained by your stakeholder solicitor, and not to be released until the LED is over. That's one protection. Protection number 2 is for common properties. We have the common property defects account, where the sum of money is actually deposited with the Commissioner of Buildings. So if there are damage or there is damage to common property, or the common property is defective, you can lodge a complaint with the COB. This is during the LED period. You lodge a complaint with the COB. The COB can inspect and then utilize the money to carry out the necessary repairs. The law also provides that the COB can ask a higher deposit to be paid as security for damage to common property. One more thing I just would like to add. For defects to common property, the time starts running from the date of issue of your CCC. So basically, these are the things that we need to know as to who you can sue and who is responsible for defects or damage to your parcel or to the common property. There are many areas where the law is still not clear. For example, do you need to get the quotation only, or do you need to carry out your repairs? Number one, right? So that is one thing. Number 2 is, how do you define a defect? How do you define a defect? A defect could be a situation where the expectations of the purchaser differ from the expectations of the developer. So the court will have to look into all factors, including your brochures, the promises, the artist's impression that is given, the price at which you pay for your premises. All these will have to be taken into consideration. Specifications in your sale and purchase agreement will also have to be taken into consideration. So very briefly, this is what I can outline for you today. And so I will invite, if you have any questions, to throw in the question now. So thank you very much. I'll see how I can address the situation. Thank you. Amiza.
All right, thank you, Mr. Patrick. I hope everyone do gain some understanding and better understanding about this topic. And now let's move on to our Q&A session, which there is a question coming from a participant. Hold on, yeah, it's from Oi Su Ming. All right, can you see the question? Okay.
Yep.
I read the question for you. Hi, Mr. Patrick. If the parcel owner had installed a water filter and modified the inlet pipe route before meter, now there is rusty and leakage happen at before meter. So this situation, who are responsible to rectify the problem? I pass to you, Mr. Patrick.
All right. Thank you. I recently had a matter on this. I do advise the JMB of one of the developments in Kuala Lumpur regarding this, where the owner had actually installed a filter just at the meter, the water meter area, and he claimed that he was allowed to do so. Now, the first question is this: if that filter is placed at a location, you see, all the water meters will be on a particular location. That location is common property. And if it is common property, then the owner has no right to put his own meter there and to divert the inlet pipe route. So this is the first problem. No owner is allowed to go in and do such kind of things. Even if the developer had allowed it, right? This cannot be allowed. because this goes against what the law provides. First of all, the developer and the JMB cannot enter into contracts for more than 1 year. Okay, that's the first problem. Now, so the second problem is you have already illegally installed a water meter there, and having installed a water meter there, right? The next problem is it's now causing a problem. It is your duty to remove it. The JMB should issue a warning, give a notice, ask them to remove it. And if they fail to remove it, they should remove it and then charge him for the cost of removal. You can put your water filter inside your parcel, not outside. Right? Not outside, because it is common property. Once there is a water outlet, there's a pipe which is servicing 2 or more units, it is already common property. But if it's only at the point where it's servicing your particular, that means the pipe is branching off to your unit alone, and you put it there, then it's yours. But if it is a pipe which is servicing to, and from the facts of this case that you tell me that it is before the meter, which means it is common property. And this person brought, the matter was taken up to the tribunal, and the tribunal ruled in favor of the JMB. So this is the fault of the owner. He has the responsibility of removing it. All right. Okay, thank you.
All right, thank you, Mr. Patrick. That's a good example. So moving on to our next question, from TF Tan. I pick up the question. Okay. Hi, Mr. Patrick. As per 757, JMBMC can make a contract more than 1 year with vendor service provider. Upon expiry, is it allowed to renew the contract for another year without having 3 main quotation?
Right. Okay. First thing, let me make one clarification. Only the developer and the JMB cannot enter into contracts for more than 1 year. The MC can enter into contracts for more than a year. All right, we must be very clear about that. Number two, of course, the purpose of allowing a developer and a JMB not to exceed 1 year is because they are temporary management bodies. If you take a situation where vacant possession has been given, the law provides that within 12 months, the developer is supposed to call for the first AGM of the JMB and thereafter hand everything over to the JMB. So, based on the structure, the dynamics of the statute, if everything goes well, within a year the JMB will come in, and then the JMB is free to enter into new contracts. That is why the developer should not enter into contracts for more than a year. The same story applies for a JMB. The JMB is a temporary body. It is not expected to last too long. Once 1/4 of the aggregate share units are issued, the MC should already come into the picture. Only the MC can enter into long-term contracts. Number two, the same contractor can be retained. If it is approved, then it can be retained. Now, you're calling for the 3 minimum quotations. I've done a case in Ipoh. I'm still doing the case. The owners have actually written to the COB in Ipoh stating that some of the contracts were done without any quotation. Now, the information I got, this is what I'm trying to look at my phone and see, is that the COB in Ipoh says that if the contract sum is below a certain amount, there is no necessity to get a quotation. So please note of that. If it is below a certain sum, there is no need to get a quotation. So you may want to keep that in mind. So I do not know the contract you're speaking about. What is the value of it? You see, whether you need to get all these 3 separate quotes. If it's a big sum, of course you need to. If it is a small sum and it's something which is considered as normal, minor repairs, minor works, nothing major, then maybe you don't even need to get a quote. The JMC can just do it. The idea of getting a quote is to make sure that the JMB funds or the MC funds are not overused or overextended. That is the whole idea. So, but if the sums are too small, then they don't need it. That is what my understanding is about this matter. I hope I've answered the question. Thank you.
Okay, thank you, Mr. Patrick. I hope it answers the question for TF Tan. Okay, so move on to the next questions coming from Siti Nurain, I think.
Okay.
Okay. Mr. Patrick, if the water pipeline leaks in the common area before entering the house tank, can the landlord charge JMB for a sudden increase in the water bill? Lepas to you.
Okay. This will come under maintenance and management. So you need to get it's good to say, it's very easy to say that there is a leak and things like that. But they need to get the proper people to come in to check where the leak is actually and whether the leak is as a result of bad maintenance by the management. As I've said earlier, the management is responsible for maintaining and managing the building. So as long as that particular pipe is servicing more than one unit, it's considered common. And therefore, it's a management responsibility to maintain the place. However, if it's that part where it's already going to the particular unit, they still have to maintain, but they may charge you for it. So I would think if in this case, you can prove that it is in the common area and that it is because of the mismanagement or poor management, because pipes leak, GI pipes leak after some time, they have to be changed. They become rusty. They need to be changed. So you have to look into that aspect as well. There must be proof of leakage, please. The case I mentioned just now, the case of 𝐒𝐭𝐫𝐚, is one very good case where this was a case of the bungalow being bought in 𝐒𝐿 in Shah Alam, where there was number of defects, which I will discuss in the seminar, and how far you can make a claim against these defects. But one of which was that water pressure was low, and therefore there must be a leak somewhere. And the plaintiffs brought in an engineer who used the JKR test to show that the water pressure did not reach the expected levels. Therefore, it must have been leaking somewhere. The defense the developers brought their own engineers who used a different test. And the High Court judge in the construction court in Shah Alam said that the plaintiff used the wrong test because JKR is usually used for public buildings, high density, and tall buildings. It's not used for bungalows. So the standard for bungalows cannot be the same as that. And there was no proof of leakage either. There was only an assumption it was leaking because the water pressure was not good enough. So we need to really confirm where the leakage comes from, who is the cause of the leakage, whether it is poor maintenance, that's all. If it is, it falls back on the management. They can't pass the buck on to the owner. Thank you.
Okay, thank you, Mr. Patrick. So let's move on to the next questions. Hold on, I'll check. By Kelvin Chong Seng Fu. Alright. Hi, Cikgu Patrick. Thank you for your brief and informative notes. Can you briefly tell what happened if the SPA under 48 month or 54 month instead of HDA is only allowed 36 month? Can we challenge on that? Pass to you, Mr. Patrick.
Okay, thank you. All right, first of all, we have to decide whether this is, you're saying HDA, I assume it is a residential unit. If it's a residential unit, then it is 36 months. Unless they have obtained consent from the minister, but this will not be given prior to execution of SPA. It's only after the execution of the SPA for some reason there has been some delay, and the delay can be justified, and the minister has got enough evidence to show that there's justification, like the MCO which came up, construction works which were held back in 2020, and Malaysia passed a law backdated, 2021 was backdated to 2020 to allow delays. But I do not think it should appear in the SPA. If it does, then the question is whether it's commercial property perhaps. You see? So because if it's a SOHO, the land on which it is could be commercial. It may still be considered residential, but it could be commercial, in which case you only have to go by your contract. You cannot go by the statutory protection. You see? Obviously, if it's a residential and they put there 48 or 54 months without consent of the minister, that would be a blatant disregard of the law. But we will need to look at the agreement carefully first. Yes, thank you.
All right. Thank you, Ms. Patrick. I hope it answers the question. So let's move on to the next question from Lee Go Ping Sean. Okay. Hi, Mr. Patrick. I'm looking for an advice. I'm a resident in a condo in Kuala Lumpur. My current JMB does not respond to emails. All complaints or suggestions are not responded or acknowledged by the JMB. When I emailed the management office, the response was it has been forwarded to committee for response. When I send reminder to the committee, there is no response. What can I do next? Thank you. I'll pass to you, Mr. Patrick.
All right. Now, first thing is, in such a situation, you should actually go down to the management office, give the letter to them, and make them acknowledge it, rather than send emails. You will need to do it. If the management office says they're closed because of COVID and things like that, leave it there. Give them a letter, hand delivered, take note, take a photograph, snap a photo from your phone, or send them an AR registered letter, because that will enable you to take the necessary course of action. And you can also, I would advise, CC a copy of the letter to the COB, Kuala Lumpur. Since you're in KL, it's Dewan Bandaraya Kuala Lumpur, COB Kuala Lumpur, and then you can lodge a complaint with the COB regarding this. That will be the next course of action which you should take to give evidence that you have actually given them all the necessary notice. Okay.
All right, thank you. I hope it helps. Okay, I think this should be our last question for tonight, Ms. Patrick. It's coming from Ashrik Shamsuddin. Okay. Hi, Mr. Patrick. I bought a unit recently where the project is completed 3 years ago. Is this mean that I still have 2 years based on VP date to inform the developer if there are any defects? Apa sih, Ms. Patrick?
Okay. Number one, you have to see your sale and purchase agreement. Your sale and purchase agreement will state that you have 24 months from the date of vacant possession to lodge any complaints regarding the unit. You can check with your lawyer who prepared the agreement for you, because there will be a stakeholder lawyer. Probably your lawyer is the stakeholder lawyer and is supposed to hold that 5% back. And you should write a letter to your lawyer if you have defects and they are within the 24 months, telling them not to release the 5% until directed to do so. So you may have 24 months. I'm not sure when you got your VP. From the date of your VP, you have 24 months, right? Because the SPA will only say that VP is to be delivered within 36 months. Of course, the court case which I mentioned earlier, the federal court case, actually now lays down 36 months is to start from the date you paid your deposit and not from the date of signing of the SPA. But in any event, your LED is 24 months. Some developers even give longer period. The better developers actually give a longer period, because you can give anything over 24 months but not below it. So if you have just taken your key, you have a minimum 24 months to lodge a complaint for any defects to your property.
All right. Thank you, Mr. Patrick. So I hope
I think maybe we can take
we
one more question if anybody has. It's about
um
8:46 now. If there's
yeah.
one more question, we may be able to take it.
I'm gonna check first, because as for now, is anyone has any question you can ask?
Because you say last question is not, so everybody stopped literally. Okay, I didn't expect that you will finish this fast. Okay,
Yeah, because there's no more question coming.
okay, all right.
Okay. So I guess that's all for tonight, Mr. Patrick. Thank you so much.
Right.
So I hope that this session, everyone gains some understanding and input. So thank you everyone for joining our talk show tonight. And before I end the session, I would like to invite everyone to join our upcoming seminar, which is on this upcoming 26th February 2022, with the topic of common problems faced by JMB, MC, and developers and dispute resolution. And this seminar will be our speaker will be Mr. Patrick as well. Okay, so if you are interested to join the seminar, you can contact our number as stated below. It's 017-856-2228. Okay, I repeat again, 017-856-2228. And you can register with us. Alright, so that's the end of our session for tonight. Thank you, Mr. Patrick, and thank you,
Thank you very
everyone.
much. Okay,
Alright,
thank you
have a good
everyone for
night.
joining. Have a nice day. Stay safe, please.
Alright,
Right?
you too, Mr. Patrick.
All right. Thank you.
Okay.